Next case for argument is Planned Parenthood et al. Versus the state et al. Counsel ready to proceed? You may proceed.
Good morning, Mr. Chief Justice, Your Honors, and may it please the Court. My name is Catherine Humphreyville, and I represent appellants Planned Parenthood South Atlantic, Dr. Catherine Ferris, and Taylor Shelton, who's here with us today. We are here today seeking binding clarity about when in pregnancy a fetal heartbeat, as defined by the Fetal Heartbeat Act, occurs. While presenting a relatively narrow question of statutory interpretation, this case has broader implications for the Court's longstanding precedent that the best evidence of legislative intent is the text of a statute. That is why statutory interpretation starts and often ends with the text. To be clear, we are simply asking the Court to interpret what the legislature has written, not to create policy. The Fetal Heartbeat Act bans abortion after the detection of a so-called fetal heartbeat, and it defines fetal heartbeat as cardiac activity or the steady and repetitive rhythmic contraction of the fetal heart within the gestational sac. I'd like to walk through each element of this definition and explain why it means the Act unambiguously bans abortion after 9 weeks. This is the case for three primary reasons. The first reason here rests on a key word: fetal. Simply put, you cannot have a fetal heart or a fetal heartbeat without a fetus. This is clear in the title of the Act and appears dozens of times throughout the text. The undisputed facts in the record here show that through 9 weeks gestation, the developing pregnancy is called an embryo, not a fetus. This is in Dr. Ferris's declaration on page 112 of the record, paragraph 11. Dr. Crockett agrees, as does the state's expert, Dr. Skopp. By my count, Dr. Skopp's declaration uses the term embryo or embryonic 18 times, but the only time you'll see the word fetal in her declaration is when she's quoting the Act. The state's approach here would effectively cross out the word fetal altogether in defiance of the statute's plain language. But it's not for a court to rewrite a statute.
Why didn't you argue this the last time we were here, but you stuck by your argument, this is a 6-week ban, and that was because that fit into your argument at the time, trying to extrapolate from Planned Parenthood 1.
Yes.
Why did you do that, and now you're here telling us something that I would say is completely different?
Yes, Your Honor. So I think in Planned Parenthood 2, as was Planned Parenthood 1, it was a facial constitutional challenge rather than a statutory interpretation case. And in Planned Parenthood 2, as well as Planned Parenthood 1, we were consistent that the line at which an embryo becomes a fetus is after 9 weeks. That's been consistent in the declaration, and when Justice Few asked us how we would interpret, how we should interpret this definition, our answer there was the same as it is here, which is that it chills conduct.
I think the other side has a lot of explaining to do, at least to me. But what I'm asking is, well, let me ask it this way. Do you think, in your broad view of the Constitution and so forth, do you think a 9-week ban is also violative of our right to privacy? That's not an issue, but what's your answer to that, yes or no?
I don't think it does, though.
Okay, then why didn't you keep silent and then put an arrow in your quiver to use later to say, in an as-applied challenge, we're talking about steady, repetitive, rhythmic contraction of the fetal heart, and you can't prosecute this doctor for that because there wasn't one, and not talk about weeks.
Right. So I think that the answer is that this act has incredibly severe penalties. So if we were to stay silent and just hope that the prosecutor here in Richland County is not going to go after Dr. Ferris or another doctor at Planned Parenthood who's providing an abortion at, let's say, 7 weeks, and then it turns out the prosecutor interprets that differently than we did, Dr. Ferris might be facing jail time, loss of her licensure, the clinic could lose its license, and so forth. And so I think that the the better interpretation here is after 9 weeks, but as the court expressly left for another day, and that day is today, it wasn't interpreting the meaning of the act. I'd like to
Following up on that, and since you hearken back to our dialogue, and I don't think any of us, I know I don't want this to become a conversation about you contradicting yourself necessarily, but the statements that you made, the positions that you took, did feed the way we wrote, and then in turn, in round one, and then in turn, the way we interpreted the second act. But you and I had a specific conversation, and I've rewatched it, and I'm sure you have too. And as I sit here now, I wish I had pressed you harder, because I didn't make you answer the question. But I gave you the perfect opportunity by setting it up. If you contend this is a 6-week threshold, then perhaps you have a better chance of getting the whole act declared unconstitutional. But if you contend this is a 9 or 10-week threshold, then you have given the people you are here to represent more of what they want. And y'all, not you individually, but your clients have persisted, in my view, with the argument that it is a bill that takes effect at the occurrence of the event that most folks say occurs at about 5.5, 6.5 weeks.
Well, I don't think we're persisting with that view here. We think the better interpretation is that it applies after 9 weeks, but we have no choice, and obviously given the circuit court's order.
I guess what I'm getting to is, I'm not saying you're wrong in that last statement that you just made, but you're having pressed the point so hard all the way through rounds 1 and 2, leaves, it set up what was basically a conversation among everyone. You look at Justice Hearn's opinion in round 1, 6 weeks. Justice Beatty's opinion, 6 weeks. Look at my opinion, and I'm focused on how many women can know within the period of time that the statute prescribes whether or not they are pregnant, and then have time to go about getting an abortion if that's what they choose. The conversation, so it's not so much about pinning you down about what you said, as it is that what you said set up a conversation that leaves us with this very clear impression that everybody's talking about the event that occurs at 6 weeks. And I just say that because I want you to respond to that.
Yes, Your Honor. So I think that this case gives us an opportunity to step back and say, it's the text that controls, and that the text is what should guide this court's interpretation. And so while, perhaps everyone was saying that, it's really an objective evaluation. And I would like to note that reviewing this court's opinion in Planned Parenthood 2, we hear you loud and clear that there are differences between SB 474 and the prior Heartbeat Act, which was SB 1. And I think that there are some key differences, and perhaps in our rush to file on an immediate effective date, we might have overlooked some of those. And so I think that this goes to the differences between SB 1 and SB 474. And so one key difference between these two acts is that SB 1 specifically defined human fetus as beginning at conception, whereas SB 474 essentially crossed out human fetus and equating that with unborn child. And so here, the legislature is free to define terms as they wish, and here it removed the definition of fetal. And so that tells the court that you need to look at the sort of common understanding. And so everything in the record in this case points to the fact that it's only after 9 weeks that an embryo becomes a fetus. This is...
Wait, hold on a second. Now, if that's true, why does it say in section 44.41.630B, if the unborn child's fetal heartbeat has been detected? Why did they use the phrase unborn child? Why did they put that in there? Why didn't they just say fetal heartbeat?
Well, I think that the legislature could choose to say fetal heartbeat, but I think the key term in there is they choose to add fetal. And so what The other side has argued is that the definition of unborn child should control entirely, but that would essentially cross out the term fetal. The term fetal has to have separate meaning. And I think that this goes to the clause that follows the term in the definition of fetal heartbeat. And that's that the cardiac activity or the steady and repetitive rhythmic contraction of the fetal heart. And so this also helps explain why this can only be after 9 weeks. And this is in Dr. Crockett's declaration. I'd point you to the record, page 159, paragraphs 31 and 32 in particular. And so she explains that you can't have a coordinated heartbeat until the conduction system develops.
A coordinated heartbeat?
A coordinated heartbeat.
But
And so
the word coordinated is not in this definition.
that's correct, but I think the terms steady and rhythmic are, and while we don't doubt that it's repetitive before the threshold that we're talking about, so it's repetitive at 6 weeks, but it's going to be this sort of irregular flashes on an ultrasound at that point. It's not going to be steady or rhythmic.
I don't want to interrupt
Go ahead.
you, but what does steady mean in medical terms?
I think that this is something where it would be, we would use the common meaning of it.
All right, what does rhythmic mean in medical terms?
I don't think rhythmic is a specific medical term. We've pointed to the definitions of both of the
Of course,
dictionary
repetitive
definitions.
doesn't have a medical meaning.
No, the word repetitive does
You
not
see
have a
that
medical
you
meaning.
can see that what's going on at this, I'm going to say 6-week point, but I mean, the event that occurs roughly 6 weeks, you can see that that's repetitive.
It is repetitive,
And it's
yes, Your Honor.
contraction too, is it not?
I think there's a contraction of the early tube that will
So
become the heart.
we're left with your dependence here, as I hear what you're saying, on the interpretation of 3 words: steady, rhythmic, and fetal.
I think that is the core of our argument, Your Honor. And I think that just,
Steady and rhythmic have no medical precision.
not to my knowledge, no, Your Honor.
Contend that fetal does.
Fetal does have precision. This is, again, uncontested in the record. So I'd, in addition to Dr. Ferris's declaration, I'd also point the court to the ACLU's amicus brief. This is at pages 6 and 7, where they cite a number of dictionary definitions and other sort of medical sources. And, you know, again, Dr. Skopp, throughout her declaration, refers to an embryonic heart and an embryonic heartbeat. And so this is not contested anywhere. I think that
Saying it's uncontradicted or uncontested, but it says detecting the heartbeat in accordance with section 4441-330A, which is the Woman's Right to Know Act. And that title and that article uses embryonic or fetal, almost as if they're equivalent. So can't we take that into account?
you're correct, Your Honor, that the Women's Right to Know Act does use the term embryonic, but it does say or, and so I think in that case, the or is disjunctive to mean 2 different things. And I think that the Women's Right to Know Act, as well as some of the laws regulating medical waste, use the term both embryonic and fetal, suggesting that the legislature understands the distinction between embryos and fetuses.
Oh, and going back to that Woman's Right to Know Act, I'm interested in kind of what happens in the real world with this stuff. If the doctor under that act, are you saying that the doctors in practice don't regularly show the ultrasound before 9 weeks because they can't detect a fetal heartbeat as it is defined in Title 44?
I think it is common practice, Your Honor, for whether you're seeking an abortion or whether you're seeking to carry your pregnancy to term, that patients would have an ultrasound prior to 9 weeks. However, I think to use the common language, they might say, do you want to hear the heartbeat? But they're not going to say, do you want to use the fetal, do you want to hear the fetal heartbeat? And I think
that's what they're supposed to do under the statute. So if they're doing that before 9 weeks is common practice, I mean, it seems like that's the ordinary and popular understanding, and indeed the medical understanding of the term in the real world.
Well, I think that the ordinary and popular understanding only comes into account when the legislature has not defined a term. And here it has defined the term fetal heartbeat, and so we need to give effect to every portion of that act. I think it also needs to be read in tandem with something Justice Few raised at oral argument last time, which is that the legislative finding that cardiac activity begins when the fetal heart is formed in the gestational sac. And Dr. Crockett explains why it's only 9 weeks that you have a fetal heart, because it's only after this point that you have the major components of the heart. So that's the 4 chambers of the heart.
Before you get away from the topic that I think Justice Hill and I are talking about is fetal versus embryo. Do you believe that medical professionals can look at these two phases and understand that there's overlap between fetal and embryo, or embryonic and fetal?
I don't think that there is overlap between
Then
those.
what would be the medical criteria, the observable things that a doctor would look at to say, okay, I see A, B, C, and therefore the transition from embryonic to fetal has now occurred? What are those criteria?
So I think that doctors are in the practice of regularly dating pregnancies, and the primary thing that doctors look to date a pregnancy is the crown rump length. They'll also take into account a patient's self-reporting of their last menstrual period, but of course, patients might, menstrual cycles vary and patients might not remember when their last menstrual period was, and so there are objective ways that doctors are able to date pregnancies.
Well, I'm interested in not hearing you say that there are objective ways. I'm interested in hearing you say what those objective criteria are. You gave me 2, one of which sounded very subjective.
As far as the crown rump length?
That one seems to me to be more objective. But when the second one you mentioned was what the patient self-reports to the doctor as the length of time between her last period.
I mean, I think that is potentially subjective insofar as a patient might not remember, but, there are plenty of patients also who regularly track their menstrual periods, and so, but the crown rump length, and this goes to...
Okay, so just real quickly, what are some other, if any, objective criteria that a doctor would look at to determine whether a unborn child has progressed from the embryonic phase to the fetal phase?
I'm not a doctor, Your Honor, and I don't think that this is in the record, but I think
okay,
that there are other markers.
It's not in the record.
There are other markers of development in addition to the crown rump length.
Let me ask.
Last question on that point, and then Justice Verdon, but would you agree, though, that when medical people would try to answer this question, that they would see, one person might see it differently than another person?
I think it is possible that one person might see it differently than another person, and I think that that goes to our alternative vagueness argument, that it's not only doctors who need predictability and certainty as to how they should...
Well, I don't see how you can argue that the use of the term fetal makes the definition clear and unambiguous, but on the other side, the fact that the word fetal can be looked at differently by different doctors makes it unconstitutionally vague.
I mean, I think this is an argument in the alternative, Your Honor. I think the better argument is that it is unambiguous, that the text speaks for itself and that the text is clear. But if you're not convinced by that, we do think that there's essentially then a divide. If you think that the term fetal does not control the outcome of this case, that there's then a divide between the stage, if you're interpreting it to say that it applies at 6 weeks, and then, but it's regulating embryonic, essentially abortions when the pregnancy would be an embryo, that's in contrast to how a doctor would interpret the term fetus.
Thank you so much. Justice Verdon has a question.
All right, and just to ask you some questions about this, your argument that this is unambiguous to begin with. First of all, let me just be clear. You believe the definition of the fetal heartbeat is one point in time. You and the state don't agree on the time, but you both agree it's one time. Is that correct?
Yes, that's correct, and that's based on the legislative finding.
And my concern is, as I was looking through the record, Dr. Ferris's statement that I have not understood at what point in pregnancy fetal heartbeat is defined by the Act refers to, or if it refers to a singular point in pregnancy at all, given the ambiguity raised by the court. So if your own expert is saying that the statute is ambiguous to her, how can we not then turn and look at legislative intent?
So I think perhaps, ambiguity might have been a poor choice of words there. I think there's a difference between uncertainty and ambiguity. And the other thing I would note is that with vagueness, as with ambiguity, it's an objective determination. So one doctor's subjective view of, I don't know what this means, while it might be evidence of ambiguity or unconstitutional vagueness, that's not what holds the day. And what holds the day is this court's interpretation of the text itself. And the court's analysis can end with the text, and it should only, as you note, turn to external sources of legislative intent if it determines that the language itself is ambiguous. And then if it's ambiguous, it should apply the accepted canons of construction which focus on the text before turning to extra-textual sources. So as Justice Hill recently noted, extraneous sources represent unenacted legislative intent at best. By contrast, focusing on the text allows the court to provide a principled approach to ascertain the statute's meaning without second-guessing the General Assembly's policy determination. And I think taking a principled approach is critically important in a hot-button political case like this. So as the court wrote in Planned Parenthood 2, the court should not turn its back on legislative deference merely because the issue is abortion. So I'd now like to talk about the points of types of legislative history that I think you should consult, and this is only if you first determine that the act is ambiguous.
Let me follow up on Justice Verdon's question. You both seem to agree there's one point in time.
Correct, Your Honor.
They say 6, you say 9. But in all these materials that I've read, and even in some of the arguments in these briefs and in some of the legislative history, it says things like somewhere between, or roughly, or about. How in the world is that one moment in time?
So, Your Honor, I think that this goes to two separate factors that the...
And let me be a little absurd here. On Friday, no. On Sunday, yes. So what about Saturday? Where is the moment in time? Could it happen on the way to the doctor's office?
I think it potentially could. I mean, I think that this goes to...
How does that give anybody any certainty?
So I think that there are ways, as I was explaining to Justice Few, for doctors to clearly determine when you would reach the mark that we're referring to. But I think that there's sort of two parts of the definition of fetal heartbeat in this case to break apart. And there's fetal, and that is a definitional term that has some sort of certainty. As we've noted throughout our papers, these other markers are developmental, and developmental processes may vary. I think the legislature recognized this when they said normally when the fetal heart forms in the gestational sac. But I think that this goes to the deference to the legislature. The legislature is free to define things as they wish, and if they say it's one moment in time, though, as a matter of medical development, there is variation, but what the legislature says has to rule the day, and I think that this is why the use of the term fetal is so critical, because there's a clear line on either side of that.
Sorry to sidetrack you.
No, that's all right, Your Honor.
Let me ask something, if you don't mind. I know we can go back and forth, and we can turn to the conflicting medical opinions, the battle of experts to discern legislative intent. You mentioned deference to the legislature, and our mission here is to discern legislative intent. And I think we all acknowledge that the statute is not written with absolute precision. And I think that sort of pushes against your argument that it's unambiguous. And I note parenthetically that you also make a void for vagueness argument, which I'm not sure how flies with your threshold argument of unambiguity. I also understand the principle that we do not discern legislative intent from after the fact statements from members of the legislative body. We look to the text. But this is an unusual situation in that we have prior to the passage of the legislation, everyone, proponents of the legislation and opponents of the legislation, without exception, referring to this as the, quote, 6-week bill. That same mantra and narrative was picked up, as alluded to earlier by Justice James and Justice Few, that was pushed by Planned Parenthood. So how do we reconcile our obligation to discern legislative intent with what we know all the legislative body understood prior to passage?
I don't think it's fair, Your Honor, to say all of the legislative body knew this prior to practice. So in, the governor and the attorney general's brief, I counted maybe a dozen individual legislators who it cites. But there are 170 members of the General Assembly as a whole, and this court shouldn't give effect just to the loudest voices in the room. So there's a lot of, sausage making that goes on behind the scenes, and floor debates are part of that, but to speculate as to what the other, 158 members of the General Assembly thought is not to give effect to the text. And I think that this goes to the types of legislative history that the court should rely on before statements of individual legislators, and those are grounded in the text.
That's a fair point, but we don't just have 10 or 15. We have so many members of the legislature. In fact, there was an effort to put amendments, tons and tons of amendments. And through that process, by the opponents of the bill, we learned what the view was about what the intent of the legislature was. The 6-week bill, which mantra was picked up by Planned Parenthood.
I think the amendments are critically important to this because they also speak to, if the legislature voted those down, that speaks to the voice of the whole legislature. And so there were 2 amendments introduced that would have substituted embryonic or fetal heartbeat. And the legislature declined to include the term embryo here. And as Justice Hill noted previously, the legislature knows what embryo means and it knows how to use it when it's there. The second I would point to is amendments that would have substituted the definition of unborn child for human fetus. And that's, again, one of the critical differences between SB 1 and SB 474 is that human fetus is undefined. And so the legislature specifically chose not to say that human fetus is from the moment of conception. And so that then moves this court into the common understanding of the term fetus.
Fair point. Thank you very much. Justice Verdon asked an excellent question, and you were going to talk about rules of statutory construction that you believe support your position. Justice James asked a question, then I asked one, and I apologize for that, but I want to give you an opportunity to address the points you were going to make earlier.
Sure. So I think just to continue with the types of legislative history that this can rely on, I'd also just like to zoom back and talk about what the legislature's intent was. And so the intent was to ban abortion after the detection of a fetal heartbeat, not to ban abortion at a specific point in time. And the legislature specifically gave some opportunity for some more limited number of abortions to occur. But when the legislature wants to talk about a specific gestational age, it knows how to do so. But you will not see the term 6 weeks anywhere in the text of the fetal heartbeat ban. And this is in contrast to the rape and incest exception, where it specifies 12 weeks. And another sort of legislative history that you can look to is prior enactments of the General Assembly. And the General Assembly previously enacted a 20-week ban. And so if it wanted to enact a 6-week ban, it could have, and it chose not to do that. I think a third source, or another source of legislative history is this idea that similar laws from other states can be construed similarly. And the court should assume that any changes between South Carolina's law and similar so-called heartbeat bans, those differences have to have significance. So we've noted some of these on page 20, footnote 7 of our brief. In addition to those, I'd also note that Ohio, Kentucky, Mississippi, and Texas all have materially different definitions of either fetal heartbeat, fetus, or unborn child. And so I think that this goes to the idea that South Carolina's law is different, as Justice Few noted at oral argument last time, from Texas's, for example.
Have you been able to detect any reason why South Carolina, the General Assembly, inserted commas?
I don't know the reason for that, Your Honor. I don't want to speculate
It's not anywhere in any of this history.
Not to my knowledge. I think that there was one amendment which would have introduced the definition, introduced the term embryo as well as fetus that removed the commas, but I'm not sure the reason for that, and I don't want to speculate. And I think that that goes to why the court's interpretation should be grounded in the text, because we're not here to speculate about legislative intent. We're here to give effect to the plain language. Very briefly in my remaining time, I'd like to turn to the rule of lenity. And its application is.
I want to, before you go there, I don't know whether the chief is going to be strict with your time or not, but I have maybe two more things I want to ask you about. One is, we've heard throughout this entire process here in South Carolina, and in fact, as similar legislation has been introduced and debated in other states, we hear the same thing. And that is that the reason this point in time was picked is because at that point in time, once that point in time is reached, there's a 95% correlation between reaching the point in time and an eventual live birth. So from when taking that idea right there, what is your understanding from a medical standpoint of which is the point in time that has the 95% correlation? Is it what you argue or what they argue?
So I think this is another critical difference in the legislative findings between SB 1 and SB 474. So the finding you're referring to, Justice Few, appeared in SB 1, but doesn't appear in SB 474. So the idea that we could take this 95%.
All right, I got that, but answer my question.
I don't know what the point in time is. It's not in the record here. And I think that there's, a host of different variation in fetal development so that, one person's developing pregnancy might have a 95% chance of being carried to term at, let's say, 10 weeks, and another person, it might be 6 weeks, and it might depend on, the age of the pregnant person, for example, other factors like that.
All right. Well, in the first argument, which you didn't argue, I think Ms. Murray argued that. There was a sequence of events that I want to ask you about. The idea that Planned Parenthood asserted from the very beginning is that this abortion cutoff ban takes effect before, different words have been used, vast majority has been used, substantial number, but before some large number of women even know that they are pregnant. So that was the kind of how this whole idea began, as why this bill would be unconstitutional. During the course of the first argument, Justice Kittredge pointed out to Ms. Murray that there's data in the record from DHEC, our State Department of Health, that something like 45% of abortions that occur in South Carolina occur within 6 weeks. You remember that?
Yes, Your Honor.
All right. Ms. Murray then responds to Justice Kittredge by saying that data is different. That data is measuring from the time of conception rather than from the time of LMP. So she responds to him, what that data really is talking about is 8 weeks in terms of what we're talking about here. And then I followed up with her by saying, okay, well then, and with the state too, what is the data? And the answer that I got from both sides is that there actually is no data. But now that your position is different, wouldn't it be true that that 8 week data, that 6 week data is right on point, down the heart of what I was pressing on from day one in this case?
So quickly, I don't think that the constitutional point should turn on the number of people that know they're pregnant. But
you might not think that.
I hear the court's ruling.
You read what I've written and
yes.
you've heard what I've said, so it's important to me.
Yes, and I think to the extent that the court is going to consider statements from individual legislators, which, I would really caution against that.
We're out of time. Let's stay focused.
The statements from the bill sponsor in the journal relies on the DHEC data in offering that essentially that data is on point precisely in the way that you say it is. And so to the extent someone's offering a justification to that, I do think that supports our point. Again, I would caution against sort of how individual legislators can kind of manipulate the record and not speak for the legislature as a whole, but I do think that that data is in there, as well as in Dr. Ferris's declaration.
If the chief was going to permit me, we're going to get to the heart of this. We have these principles of law that we've written about that say that the legislature is presumed to know what the court has said and about what the law is. Would it not also be true that the legislature is presumed to know what the administrative agency that is tasked with the very subject matter of the legislation under consideration has said about what's going on in our state?
I do think that's correct, Your Honor, and I think that the DHEC, or now Department of Public Health, milestones support us. So they say that, it's a fetus only.
What do you think? You've read my opinion in 1 and 2. If I had in my hands, data showing that almost 50% of abortions actually do take place during the period of time when the act permits it, and if I was aware of this principle that you and I think have just agreed on, that the legislature is presumed to be aware of that, how would that have affected my opinion in the first case?
Well, I think that that's maybe a bit subjective as far as having, what is a substantial number. As you noted, there's a number of different turns of phrase that have been.
Yeah, but remember, what I said in my first opinion, I was very pointed in saying it's not up to the court to determine what is the correct or sufficient number. That would be up to the legislature. My point was that the legislature hadn't even considered it. But if they had, if there were data that shows where the point is, and the legislature is presumed to have had that data in their scope of materials that they're considering during the legislative process, presumably they would have considered it. How would that, you don't have to answer the question. It's a rhetorical question, but it's a serious question. The point being that if we had started this process with y'all taking the position that this is not a 6-week bill but a 9-week bill, then the outcome of Planned Parenthood 1 would probably have been different.
I take the point that it's a rhetorical question, and I think, that perhaps should have been the case. But I would just, again, point to the differences when the legislature said, okay, we're considering this data that Few told us to, and we fixed it. I think that those are where the differences between SB 1 and SB 474 come critically into focus. And, I know that my time is up, Your Honors. I also.
Time and reply as well.
Okay. Thank you, Your Honor.
Thank you so much. Counsel?
Mr. Chief Justice, and may it please the court, for the third time in as many years, abortion is back on this court's docket. But unlike the first 2 cases that involved a facial challenge, this one involves a narrow yet important question of statutory interpretation. What does fetal heartbeat mean, such that the 2023 Act's protections for unborn life apply? The circuit court said it was clear beyond a shadow of a doubt that that point was approximately 6 weeks, and the circuit court was correct. The text confirms this conclusion. Fetal does not draw the bright line at 10 weeks that my friend suggests. A heart exists from at least 5 weeks in pregnancy, and there is evidence to support the General Assembly's conclusion that a heart at approximately 6 weeks has a steady and repetitive rhythmic contraction. But at best for appellants, given all that this court said about timing in Planned Parenthood 1, and all that appellants themselves have said about the timing of the 2023 Act, the term is ambiguous. If that's the case, all the tools of statutory construction, including and importantly the legislative record, are before this court, and the conclusion is the same. The law protects unborn life from approximately 6 weeks, and this court should therefore affirm. I'd like to jump directly to what was the heart of the conversation with my friend on the other side, and that's the meaning of the word fetal. And I've got at least 4 reasons fetal does not draw a bright line at 10 weeks of pregnancy in this act. Number 1 is fetal heartbeat laws across the country generally. They have consistently been understood, no matter what the definitions are, to apply at approximately 6 weeks. For instance, take Texas. When its law got to the U.S. Supreme Court, both Chief Justice Roberts and Justice Sotomayor called it a 6-week law. Second, we have academic studies that use fetal to mean something less than 10 weeks. So, for example, the Journal of Human Reproduction, that's a peer-reviewed publication from Oxford, has studies going back at least 24 years that uses the term fetal cardiac activity or fetal heartbeat to identify pregnancies for studies at less than 10 weeks. Third, you have the Act's findings itself. The Act in Section 1, Subpart 3 says a fetal heartbeat is a key medical predictor that a child will reach live birth. Justice Few, you connected that in Planned Parenthood 2 to the 95% finding in the 2021 Act. And I would note the other finding in the 2021 Act that was finding 1.1 about a fetal heartbeat being a key predictor. But tie it to finding 1.3, that's the state has a compelling interest in protecting unborn life. This point we're talking about, Justice Few, to one of your last questions to my friend, was, are we talking about the approximately 6-week point or the approximately 10-week point? It's that 6-week point. That's what that 90+% studies go to.
And you're going to tell us, but how do we know that?
How do we know that? I think this is important when I want to put the point, let me start. I want to point the court to Owens because I think Owens is instructive on this point. Last summer, this court explained in great detail the deference that is due to the General Assembly and its legislative findings. They can be expressed, but as this court noted, they can also be presumed. And as long as there is any evidence to support what the General Assembly did, as long as it's not clearly erroneous, there must be deference to that. So a couple of places we can point to, they're the studies I referenced earlier. You also have, for example, the American Association of Pro-Life OBGYNs had an amicus brief in Planned Parenthood 1, where at page 7, they're citing a book by Keith Moore called The Developing Human that explains how there is blood pumping through the unborn child at the end of the 5th week. That is all evidence that says there's a heart, it's functioning, there's a steady and repetitive rhythmic contraction. I appreciate that my friends on the other side may disagree with that conclusion and may go the other way on the medical evidence. But as the court's opinion in Planned Parenthood 2 said, deference to the General Assembly is not diminished because there is medical evidence on both sides. In fact, the U.S. Supreme Court has noted when there's that type of evidence, perhaps even greater deference should be given. The General Assembly reached a conclusion here that there is a steady and repetitive rhythmic contraction of the fetal heart at approximately 6 weeks.
How do you get back or get past the fact that if you first look at the words on the page, don't dig into the past or the history, stay with me there. The words 6 weeks are not in the text of the statute.
What the statute is doing, Justice James, is not drawing a bright line at a number of weeks or using a number of weeks as a heuristic for a point in pregnancy. Instead,
so that gets to the question of what's a fetal heart.
Correct. And I think I've given...
What is it? In the medical science, what is it?
A fetal heart is a term that is commonly used both in academic publications like I just mentioned and in common usage in legislative debates in South Carolina and across the country to refer to a point in pregnancy at approximately 6 weeks when that heartbeat can be detected via ultrasound. But Justice James, I want to just say this perhaps. If you think fetal heart on its face has no clear meaning, at best it has to be ambiguous here. You've got this court and 4 justices more than 80 times in Planned Parenthood 1 calling it a 6-week bill. You have Planned Parenthood calling it a capital S, capital W, capital B, 6-week ban more than 300 times in their filings. And in Planned Parenthood 2, in their brief in that case at page 42, note 50, they called the 6-week mark the hallmark feature of the 2023 Act. If it is possible for the term fetal heartbeat to unambiguously mean 9 weeks, I don't think it's conceivable that any of those things I just described could have been true. I don't think there's any way 4 members of this court get an unambiguous term wrong in the same way. I don't think there any way lawyers get that term wrong in 2 separate cases in this court plus cases in federal court. So if that's the case, Justice James, the term's ambiguous. And then you've got all the tools of statutory construction at your fingertips.
Before you get to that ambiguity, I want to go back to what Justice Few brought up about the 95% correlation. And you know, it says in Section 1, subsection 1, fetal heartbeat is a key medical predictor that an unborn child will reach live birth. So what is the difference between 6 weeks and 9 weeks on that prediction rate? Is there any evidence about that?
I'm not aware what the numbers are at 9 weeks. Presumably, Justice Hill, every week you go further into pregnancy, the child has a better chance of surviving.
I don't want to presume. I want to know. So
I appreciate that. I think the fact that we don't have studies And no one talked about what the percentages were at 9 weeks or 10 weeks.
Well,
It's telling.
under the Woman's Right to Know Act, which is how you detect the fetal heartbeat, it states that the doctor has to show the ultrasound to the mother, so forth, and also that the DHEC should come up with regulations that will show this number. Has that been done?
Justice Hill, off the top of my head, I cannot remember. We can certainly check and submit a supplemental letter of authority if it's been done on that front. I just don't know standing here today. Justice James, going back to your question about, on its face, fetal heartbeat doesn't have a number of weeks. As we've explained, if it's best, it's ambiguous. At that point, all the tools of statutory construction are available. And I think what's important, 2 points particularly about the legislative record that are important. One is that we are not looking to post-enactment statements of legislators. Cases from Questwick back to Greenville baseball make clear that that's off limits. Every statement we cite is from a committee debate or a floor debate. The second thing that's important
And those
is
are
that
the ones you cite.
at pages 15 to 19 of our red brief. The second thing that's important.
Well, you also have a footnote on page 3 that we'll talk about in just a minute.
Certainly.
Go ahead.
The second point is what's not in the
No,
legislative
I'm
record.
sorry, that's Mr. Heydrich's brief. I apologize.
Well, then I'll leave that for Mr. Heydrich, if you will. The second point is what's not in the record, Justice James. This court in Kennedy 24 years ago, in a case about retirement benefits, noted that the most powerful indication of legislative intent is the lack of legislative record in debate. No one in this case.
That's a good point, but that was a point about that case. It's not always the most powerful indicator.
Correct. And I'm not saying it's the most powerful one here, Justice Few. I'm just recognizing
You're saying that Kennedy correlates to this case because here it is also the most powerful indicator.
precisely, and that's the dots I'm
Not in
connecting.
every case.
Exactly. Certainly some cases it wouldn't apply, but here you've got days of debate in the Senate and the House, and never a person says this is a 9-week or this is a 10-week law. Not a single person. If the General Assembly were debating a new abortion law in the aftermath of Planned Parenthood 1, when this court 80+ times had called it a 6-week law, if they were intending to do a 9 or a 10-week law, presumably someone would have stood up and said, well, here's a major difference that makes this law constitutional and lets a woman know she is pregnant and gives her the time to know that. The fact that no one, including no proponent of the 2023 Act, ever said that is compelling evidence that everyone continued to understand that this was the same approximately 6-week law based on the same point in pregnancy that had been the focus of the 2021 Act.
Let me ask you this. This talk about weeks. I'm looking at a situation in the exam room where a doctor is not going to be talking to himself or herself about weeks. If the woman says, my last menstrual period was 8 weeks ago, and he doesn't detect a steady, repetitive, rhythmic contraction of anything, he's going to disregard her report. 8 weeks. So it seems to me that this focus on weeks ignores what really is going to happen. What is the doctor going to detect? That, to me, has nothing to do with weeks, because to me, that's quite arbitrary. What do we do in the exam room?
Certainly, Justice James, and I think that's one of the hallmark features of this act is that it's not about a specific number of weeks.
But that's all y'all are talking about.
I think what we're using is 6 weeks, and we try to be good about saying approximately because the 6 weeks is a heuristic. It's a rough estimate of when this point in pregnancy typically occurs. For some unborn children, that heartbeat may develop a few days earlier. For some unborn children, it may be a couple of weeks later. But in the mine run case, that heartbeat develops at approximately 6 weeks. If a doctor detects that heartbeat, whether the evidence, whether the woman's reporting or anything else suggests the pregnancy is 5 weeks, the law protects an unborn child. If at 8 weeks or if at 9 weeks there is no heartbeat, then the law does not protect that unborn
Why
child.
can't our answer to this question, or Judge Coble's answer to the question, is he says it's a choice between 6 weeks and nothing. Y'all said it's a choice between 6 weeks and 9 weeks. Why can it not be a choice between whether or not the doctor detects what the statute says, and then the doctor is able to exercise that professional judgment?
I think it is, at its core, Justice James, about the doctor detecting that. I think the debate we've been having in this case is that thing that's being detected that cardiac activity that is often found at 6 weeks, or as my friends on the other side say, must it necessarily come after 10 weeks when there is a fetus?
There we go with weeks again.
They are, but I think my friends on the other side are the ones drawing a line at weeks, because they're looking at the word fetal and saying that necessarily means you have to be post 10 weeks and then have a
your
heartbeat.
brief or Mr. Heydrich's brief, I can't remember which, you rarely talk about fetal. You spend all of your time talking about embryonic.
That may have been Mr. Heydrich's brief. I can't recall. I think what's important, Justice James, is that you recognize the word fetal is not drawing a bright line at 10 weeks. And once you recognize that, then we can recognize that the cardiac activity that is a fetal heartbeat under the Act is something that can exist before 10 weeks. And then,
What is an embryonic heart?
Your Honor, an embryonic heart, I think, would be a heart of an unborn child before 10 weeks.
Okay,
But I don't,
Does that have a steady, repetitive, rhythmic contraction?
certainly
Okay,
it
so
could.
why couldn't the definition say steady, repetitive, rhythmic contraction of the embryonic heart?
The General Assembly could have written that statute. I think it would have had to have also said and or fetal, because after 9 weeks, once you get to 10, there is no embryonic heart anymore if we're going to use my friends on the other side's definition. I think what we're looking at here is how the General Assembly intended to use the word fetal.
But the General Assembly, in its exercise of intent, copied and pasted definitions from other states. To me, that indicates no real intent to examine what they were implementing. It's an intent to enact what somebody else enacted.
Well, I think what the General Assembly did in the 2023 Act, respectfully, Justice James, is it took the same definition from the 2021 Act that 4 members of this court had said was a 6-week law, and it used the exact same definition for fetal heartbeat. I mean, it was relying, Justice Few noted, the General Assembly is presumed to know what this court has said.
That's a fair point.
This court said
I wanna
that was a
interrupt
6-week
Justice
law.
James, but just for 1 second, this is on point with what he's asking you. Can you take a minute and tell us in the best terms you can what it is that a doctor would see, not the number of weeks, what would a doctor see that would indicate to the doctor that the ban has taken effect under your interpretation of the definition?
I'm going to do this having not been to medical school, so let me try to explain it in maybe simple terms and not try and medicalize the answer. You're going to see the steady heart, I'm trying to not use the statutory terms, Justice Few, to help out here. You're going to hear the consistent heart rate of the unborn child when you do the ultrasound. So when you go in, I mean, so many mothers are familiar with this. You go in for that confirmatory ultrasound at 5, 6, 7 weeks, and they do it, and there's that whoosh, whoosh, whoosh sound, and that heart beats 110-ish beats per minute. You're going to get that consistent reading on the ultrasound machine, that there is that heartbeat in the unborn child. If you have that, regardless of when you are in pregnancy, the Act protects the unborn child. If you don't have that,
Does your answer to my question, which is also, I think, an answer to Justice James's question, depend on the use of the word heart? Or because there's been a lot of discussion in here about electrical impulses.
the heart is there at 5 weeks. It's in its earliest stages, to be sure. It's not fully formed, but the heart is there. That organ will be and will only ever be a heart. So my friends on this side want to suggest the statute is, if I may, Mr. Chief Justice.
Yes, I want to go back to Justice James, let him finish his
Certainly.
questions.
It never suggests the heart has to be fully formed with all of its parts and all of its chambers as an adult heart would be beating, or even a child's heart would be beating at the end of pregnancy. That organ exists, and even if it's in its earliest forms, which Planned Parenthood admits on its website, happens between 5 and 6 weeks, we can check the statutory box of heart.
And a brief question.
Yes, sir.
Is there a general consensus in the scientific community about when the embryonic stage ends and the fetal stage begins?
I think there is a general consensus.
But they're all greater than 6 weeks? Is that
That they are, but if I may, that's not how the General Assembly has used the word fetal here.
Okay,
And for
I
all
got
of the evidence we discussed, I think that's why.
That's it. Thank you.
Thank you, Mr. Chief Justice.
Thank you.
Mr. Chief Justice, may it please the court, Thomas Heydrich for the state and the Attorney General. I'm going to do my best to do a little bit of cleanup here and sort of respond to some questions that have been asked while also reiterating a few points. So forgive me if I'm a little bit repetitive. But at the outset, I just want to say we do agree the 2023 Act generally prohibits abortions at a single point in time at approximately 6 weeks of pregnancy. And a point Mr. Lambert started off with I think is helpful for understanding here, because really this is a case about statutory interpretation and how are we supposed to look at the language used in the statute. And that's true whether we're applying the plain meaning rule or if we look to legislative intent. And that's just the simple principle that context matters when we're looking at a statute. Mr. Lambert started off by noting that the South Carolina 2023 Act was passed on the heels of similar fetal heartbeat legislation around the country. And to address a question that you asked, Justice Few, and I think, Justice Hill, you picked up on as well, a lot of this legislation was prompted by the idea that there is an identifiable moment in time when the unborn child's heart forms. Dr. Scott tells us that that's about 5 to 6 weeks pregnancy. She also tells us in her declaration at page 253 in the record that that's the point in time that's medically significant where we know that the child has a great likelihood of achieving live birth. Chief Justice Kittredge, I think in one of your concurring opinions, you said that figure was at 95%. I've seen that at 90% also referenced, but that really was what the impetus for much of this fetal heartbeat legislation around the country was, that we know at about 5 or 6 weeks of pregnancy, depending on the pregnancy, an unborn child's heart starts to perform the function of a heart. And Justice Few, I think this is addressing a question that you were asking for. What's the doctor looking for in practice? What I'd suggest is that this actually reveals a weakness in the appellant's argument. What they're suggesting is you'd actually have to be looking for an image. They would be suggesting you'd be having to look for the image of a heart that looks like a heart we may all think about, 4 chambers. But that's actually not what the law requires. The law is listening for a sound. And it is at 5 or 6 weeks where you actually see the heart pumping blood through the body of the unborn child. That's what's necessary for live birth. We know that if that does not happen for an unborn child, that the child is very unlikely to reach a live birth. That sounds obvious, but that really is, I think, a lot of the impetus behind these laws.
But the sound is not something that the naked medical ear can hear in the examination room, right?
Yes, Justice, that's correct.
The sound is, as I've read what's been said, the sound is actually a function of the instrument that is being used to examine the woman.
Yes, Justice.
And the sound's created by the instrument. Is that correct?
I think that's right. That's consistent with my understanding, but it's detecting something, which is detecting the blood flow within the unborn child's body. And I think that's what's significant. I think that the appellants themselves concede that under the ordinary and popular language that we're talking about, and that's where this court's statutory analysis first starts, most doctors do say, and I think Mr. Lambert alluded to this as well, that's what you're listening for, your baby's heartbeat. And that's what your doctor would say at about 5 or 6 weeks of pregnancy. And Justice James, this is building off some questions you were asking, I think. You're right, we do use the terminology 6 weeks. That's rough hand, as y'all pointed out. That's terminology appellants used consistently. But what we're looking for is a biologically identifiable moment in time for each unborn child. And that's what Dr. Scott is describing in her declaration. That's when the heart is formed. It admittedly has not taken its final shape yet, but I think appellants would even concede that is the heart. Nothing will change. It may develop, but the heart is performing its function. Dr. Scott makes the comparison to the human brain, which obviously forms at an earlier stage, but continues well into adulthood, and for many people, much later in life. So I think those were just an attempt to respond to some of the questions that I heard asked at this point in time.
Let me just hypothesize that so one of the things that is being argued here is that a doctor doesn't know what to look for. So hypothesize that someone's writing an opinion that is trying to articulate your position as to what the doctor is looking for. Would something like cardiac activity means a measurable, detectable electrical impulse that comes through the ultrasound as a sound, that comes also from the developing heart in a way that contracts in a steady, repetitive, and rhythmic contraction that moves an early version or form of blood through the body?
So, Justice Few, I'd refer you to...
I just wrote that out. I'm just trying to figure out how to bring this down, because like Justice James is correct to point out, you can't just tell a doctor, don't perform an abortion after 6 weeks.
No,
You got to give the doctor some objectively discernible criteria to use in determining whether he or she can go forward with what the patient is asking them to do.
No, I understand your question, Justice Few, and you're right. The law does not set a hard 6-week line. But what I'd suggest a doctor would be looking for is what Dr. Scott outlines in her declaration. I think that's something that's familiar to most medical practitioners. I, in fact, think I saw something in the paper today talking from a medical practitioner's perspective saying,
In the Post and Courier.
we are familiar with what 6 weeks means. It tracked Dr. Scott's declaration fairly closely, I thought, which was an interesting
So
point.
what would us saying 6 weeks or 9 weeks add to the body of law in this state? To me, that means nothing. What you're saying is the definition of fetal heartbeat takes all that into account, and then when the doctor's trying to determine what is there, it's not a 9-week pumping mechanism, it's a 6-week pumping mechanism.
I think I'm
I'm trying
understanding
to figure
your-
out how that helps anybody.
So I think that what you would be identifying, Justice James, so we can put aside the 6-week, 9-week dichotomy for a moment.
Do that for 2 minutes.
Let's think about what Dr. Scott says is the unborn child's earliest form of the heart. I think she describes that maybe as an S-shaped structure, but it's performing the key functions of the heart at that stage. So that would be where we would say the line should be drawn at that point. It happens to coincide somewhere around the 6-week range. What I think appellants are saying is, no, well, I don't want to speak for them. I'm not sure that they're necessarily saying, no, that's not a heart, but they're saying for it to be a true heart, it actually has to look more like a heart. It doesn't have to just be performing the function of the heart. What we're saying is at 6 weeks, the unborn child has an organ that is performing the relevant function of a heart, which is to pump blood through its body. That's where we would say the line should be drawn. That's consistent with Dr. Scott's report. And I think importantly, and this is circling back to the point I was making earlier, I really think that's consistent with what we saw in all of the fetal heartbeat laws around the country. I was going to refer you, Justice Few, to Dr. Scott's declaration when she makes the point that it is at this period of time when the heart has first formed. Justice James, forgive me for saying it, about 6 weeks. She relies on a 2004 study that found a conclusion that this is where you see a high likelihood of achieving live birth. I'm not going to say that was the first study for the impetus of all these laws, but I think many of these laws have relied on that study in part.
Isn't that position also consistent with, and I'm sure Counsel for Planned Parenthood can chime in on this when she comes back up, but doesn't it fit into Dr. Crockett's definition of cardiac muscle cells that she talks about in her affidavit?
I think that that was her attempt, and she wasn't obviously looking at Dr. Scott's declaration with the benefit of hindsight. I think that was how she was perhaps characterizing that time. I think Dr. Scott may disagree, but I think they would both agree that those cardiac muscle cells are contracting at that time, because I think it really is indisputable that blood is flowing through the unborn child's body at that time. It's the electrical impulses making the muscles contract. That's what moves the blood and the oxygen,
Well,
which is...
she makes the statement that the cells grown in tissue culture will begin to beat in unison with one another, even outside the body if they connect. I assume that's talking about the 6-week rough period. In fact, she cites a treatise called Larson's Human Embryology.
That sounds consistent to me, Justice Hill, without looking at it. There is one final point, and I think that y'all have alluded to this question, but I actually think it's an important one, and this might be a closing point unless y'all have more questions. But I do think that it's important to ask appellants about what line they are drawing in this case, because I actually think, and I don't mean this as a negative criticism, I don't think they've been entirely consistent. Because if you look at Judge Coble's order, he called it a 9-week ban. If you look at their latest reply brief, they actually were saying it was 9 weeks plus 6 days. If you also look at a footnote that was filed on their motion for for the preliminary injunction, I think a footnote 4, they characterized 9 weeks actually as a conservative period, while saying that a true fetus may not exist until 10 weeks, and in some cases, a heart might not be at 12 weeks. So the only reason I'm mentioning this is I think this is something that y'all have already sort of hit on with your questions. I think appellants are going to have a really hard time suggesting that this is unambiguously a 9-week ban, particularly when they have not been consistent in the terminology they're using there as well.
Let me ask you one more question, and this goes back to the legislative debate. In your motion to dismiss, which I'm on page 243, you say, or you said, the General Assembly intended to prohibit abortion following the detection of embryonic cardiac activity, which often occurs around 6 to 7 weeks. And then you quoted the American Pregnancy Association, the heartbeat of an unborn child can be detected between 6.5 to 7 weeks. Again, to me, that demonstrates that this labeling of weeks is something that's not helpful.
No, I think that's a fair point, Justice James, and I think those sources really just reflect that the biological reality will be different depending on the patient. So
And that study, or that quote, is something that Senators Massey, Campson, and Grooms included in their statement on the floor of the Senate during the debate of this. So the statement that is uniformly 6 weeks, 6 weeks, 6 weeks is not 100% correct. That's picky on my part, but it still demonstrates to me perhaps the uselessness of these numerical labels.
no, Justice James, I mean, it may be picky, it may not be, but I think it's correct. So I agree with you.
Thank you.
So your view, and it maybe Counsel Lambert as well, is the law does not set a hard 6-week deadline.
Yes, yeah, that is correct, Chief
That's a
Justice
quote
Kindred.
I
Yeah.
wrote down that you said.
Yes, Your Honor.
Typically, it may occur at the 6-week mark. You also said that the legislative intent is not a time, but, quote, a biologically definite moment in time as measured by the statutory definition. Is that correct?
Yes, Chief Justice Kittredge. And I think that's consistent with their finding, which I think is the first finding of the Act.
Let me see if there are other questions the
So
court may have.
just, I'm sorry. I don't-
Justice.
Go ahead.
So just so I'm clear, and I want to make sure that I'm understanding what your assertion is here. We're not talking about 6 weeks or 9 weeks. That is just helpful in our ascertaining the legislature's intent, ultimately, if we find this ambiguous, the legislature's intent in defining these terms in statute. What would typically be going on at 6 weeks? What would typically be going on at 9 weeks? Is that a fair statement?
That's exactly right, Justice Burden. And it may be as high as saying, and I'm not sure if Dr. Scott references a statistic in her declaration, it may be that in 90% of cases, it is at the 6-week point. I think that why we have to use the approximate language, and this is just in the interest of candor, in some patients or in some women that could theoretically be earlier. I think there was a reference to that. That could be 5.5 weeks. It could be later at 7 weeks as well. But I think what we generally see based on the science is that in most cases it is 6 weeks, and that's what leads to the shorthand debate about 6 weeks, also with the media events surrounding it too.
Maybe other questions.
So in trying to figure out what that thing is that occurs that might be 5.5 weeks or 6 weeks, it does seem to me that what you just pointed out from Dr. Scott's affidavit or report, which is in paragraph 10, I think, on page 253 of the record, where she says, and I'm going to leave out a couple of words because it's just the number of weeks. She says, researchers have found that the presence of a heartbeat, skip the words, indicates that the baby has a very high chance of surviving until childbirth. And that cites, as you noted, a 2004, apparently a medical paper. So it seems very important to me because, well, they're going to say that means 9 weeks. You say that means 6 weeks. What I'm interested in is what does the research show is the thing that is observed objectively by the doctor that then correlates to the very high chance of surviving. Sometimes that number's been thrown around here as 95%. And in fact, I think that idea first came up, or it came up at least as early as like 2012 in Ohio, when they were trying to pass essentially the same act. There was a report that was filed with the appropriate committee up there that's talking about this point in time being the 6-week observation. And anything you can add to help me understand that is appreciated.
Well, Justice Few, again, I think that what you're looking for from the medical perspective is the blood circulating in the unborn child's body? And Dr. Scott describes that as when the heart is first formed, and I think that's sort of the main contrast we would draw with the appellant's position. We're looking at when the heart is first performing the function of the heart.
Okay. Then this statement that Dr. Scott makes in paragraph 10 that I just referred to, is there any indication that the legislature had this information at its fingertips, members of the legislature talked about in committee or otherwise, in either 2021 or 2023 when they enacted the bill?
I think, Justice Few, there's a statement that I think was made on the Senate floor talking about the availability of medical reports that I think could have included that. I think that's in our brief as well. And I think, and again, this circles back to the initial larger point, we again assumed the legislature was aware of all of the debates surrounding fetal heartbeat legislation around the country, and uniformly around the country, that has been interpreted to be at approximately the 6-week period, which is again based on the period identified by Dr. Scott. Thank you, Your Honor.
Counsel, thank you very much. In reply.
I'd like to start with what you heard from my friends on the other side. So in response to Justice James' question, you heard Mr. Lambert say, the General Assembly could have written it to say embryonic heart, but they would have had to say embryo or fetus. I think that's telling. And in response to Justice Few's question, Mr. Lambert said, I'm trying not to use the statutory terms. The state is simply trying to run away from the plain text of the act. You also heard Mr. Lambert rely time and time again on the 2021 Act rather than the 2023 Act. As this court made clear in Planned Parenthood 2, there are marked differences between the two laws. You heard Mr. Heydrich say that context matters while starting with the context rather than the text itself. I'd also like to respond to what Mr. Heydrich said about this sort of 9 versus 10 week mark and the idea that we've somehow shifted our position. You'll see throughout our papers, both at the trial court as well as here, that we never say at 9 weeks. We're very careful to say after 9 weeks because this is what is clear to doctors. When you have bans that say, like Florida's, for example, that say at 6 weeks, doctors are left guessing, does this mean 6 weeks and 0 days? Does this mean 5 weeks and 6 days? Does this mean 6 weeks and 6 days? And so the term after 9 weeks will give clarity to our doctors. They know what this means just as they know what a fetus is rather than an embryo.
You referenced Florida. They ban abortions when, quote, the gestational age of the fetus is more than 6 weeks.
That's correct, Your Honor, and I think that this goes to the difference between other states' bans. So Florida is an outlier in that it's the only one that bans abortion at 6 weeks. But as I noted previously and as we noted in our briefing, other states have markedly different fetal heartbeat acts, and you should assume from those laws that those differences have meanings. I'd also like to refer to what Mr. Lambert said about other states' decisions and interpretations from other courts at their 6-week bans. So not only are those cases different, but they were also, like Planned Parenthood 1 and Planned Parenthood 2, they were facial constitutional challenges, not statutory interpretation cases. And so to my knowledge, this will be the first statutory interpretation case of any sort of heartbeat ban, and it's really important to look at South Carolina's specific language for that reason. I'd also like to touch on what both of my friends said about deference to legislative facts. I think Owens is very clear, as are older cases like Richards, that the deference to legislative facts is when we're talking about constitutional cases, and statutory interpretation cases, I think, are different. You're looking to whether or not the legislature has authority, constitutional authority, to proceed with some sort of enactment, and I think that that goes to what the court found in Planned Parenthood 2 as far as the legislative findings in the 2023 Act.
And usually it's economic legislation, too.
That's correct, Your Honor. And I'd like to go to your point, Justice Hill, about how you're listening for a sound and how the sound is not audible at 6 weeks. So this is in Dr. Ferris's declaration on page 111, paragraph 9 of the record. And Dr. Crockett explains why you can't hear a heartbeat until later on, because the sound of a heartbeat is the valves opening and closing. And so I think that that's really critical, this idea that you can hear the heartbeat. And in Dr. Crockett's declaration, she describes what a heartbeat actually is on page 155, paragraph 17 of the record. And, Mr. Heydrich talked about you're supposed to be detecting blood flow as it moves through this early embryonic tube. There's nothing in the act that says we're talking about detecting blood flow.
What's the significance of Dr. Crockett's paragraph 31 then, on page 159, that I was referring to earlier about the cardiac muscle cells? What's the significance of that for our purposes here today?
So, I think that those are early muscle cells. But, I think you noted that this is in a human embryology textbook, and I think it's relevant that it's embryology. This is not talking about a fetal heart there. I'd also like to point out what my friends on the other side about saying, a doctor is going to tell you that you're going to hear a heartbeat. Again, the doctor is not going to use what is the statutory definition here, which is fetal heartbeat. And so to the extent that a layperson might use heartbeat to describe what is available, what is detectable at 6 weeks, it is not a fetal heartbeat as it is defined by the Act. With regard to the floor debate statements, I'd like to first talk about Kennedy briefly. And, I hesitate to, and we're not arguing that this court should overturn Kennedy, but I think taking a close look at Kennedy is instructive here. And the disagreement between the dissent and the majority opinion in that case. So I think when the court is saying, the absence of the debate and the legislature must not have intended for there to be big changes, I think that that's really speculative as to what the absence of any sort of legislative debate statements means. And then I think also ExxonMobil, which the governor cites in his brief, talks about legislative history and the danger of distortion that individual members can make of a legislative record by putting something in a committee report, for example, and that doesn't tell you anything about the intent of the General Assembly as a whole. And lastly, I'd point this court, the court's decision in Talavas v. Kaminsky, which says that floor debates in particular are not a reliable source of legislative history. And I'd like to sort of close with Justice James, your inquiry about this idea of, what does saying any particular point in time tell a doctor, or what does it do in this state?
I'm talking about it when referring to weeks.
Weeks, yes, correct. And so I think that the idea that the fetus-embryo divide is a specific bright line, we acknowledge that there's some variation there, but we've been consistent that we are taking a conservative estimate at the earliest markers, the earliest time all of the statutory elements of SB 474's definition of fetal heartbeat can be satisfied. And so the ACLU's brief notes, for instance, that some people might define a fetus as starting at 11 weeks. I would also urge the court to turn to the ACOG website, which I know has been the product of some debate and whether or not our position is not able to be reconciled with this. ACOG uses this 11-week mark. And so we are saying that the absolute earliest that someone is going to call this a fetus is starting at 10 weeks and 0 days. And so in other words, up to 9 weeks, 6 days, that's the point where you have an embryo and you cannot have a fetal heartbeat when you do not have a fetal heart. But what the interpretation that we're asking you for is that, and I think, we're specifically asking for the trial court to reverse the trial court's decision of preliminary injunction, but I think that this court could enter a final ruling in this case. And so we're asking for a declaration that in the act, cardiac activity and the clause refer to one moment in time, and that relevant moment in time is after 9 weeks, which is consistent with the medical consensus on when a pregnancy becomes a fetus, when the heart is formed, and that it's only after this point that the heart's contractions are steady, repetitive, and rhythmic. And I think that this goes to the human consequences here. And so, you could say, we're not going to issue an interpretation of the act, or we're not going to draw a bright line. And again, we're asking you to give us clarity on this. And I think it's really for certainty for doctors. Without certainty, no doctor is, and this is the status quo as it exists, no doctor is going to perform an abortion in South Carolina at, let's say, 8 weeks at this point, because of the grave criminal consequences that they face. And so as a result of that, it's doctors who are facing potential jail time, and it's South Carolinians like Taylor Shelton who are being forced to flee the state if they're able to get an abortion. And in the alternative, if the court finds that the act is ambiguous, we would ask you to rule that it rises to the level of unconstitutional vagueness and enter a limiting construction of the act such that it applies only after 9 weeks. And in addition to showing a likelihood of success on the merits, I believe we satisfied the remaining factors for a preliminary injunction, which is that we will have irreparable harm absent an injunction, and that we have no adequate remedy at law. Unless the court has any further questions, we would ask it to reverse the circuit court's preliminary injunction ruling.
Thank you so much.
Thank you, Your Honor.
Appreciate fine arguments on both sides. We are adjourned.